All right, ladies and gentlemen, welcome back to the last chapter of Unit 1. This chapter we will be focusing more on the legal aspects of the criminal justice system, particularly looking at procedural issues, procedural justice, and the few amendments in the United States Constitution that govern over these procedural issues in law. So to get started, what we're going to talk about basically is the variety of laws that are out there. So in this class, we will be talking mainly about criminal law. However, there is a whole other body of law entitled civil law. We're not going to be focusing on that, but civil law is basically when you say, I'm going to sue you, or an injury happens to you, you sue a company, something of that, and you put a tort in with a civil court. So civil law is important to study on its own, and there's certainly a variety of classes that focus on that, but for this semester we're focusing more on the criminal aspects of it. And within the criminal aspects of law, there are three different things that need to be discussed. First is substantive law. And substantive law basically are the penal codes that prohibit certain actions. It is illegal to smoke marijuana. There is a law on the books that says that. However, if you are found guilty of one, or if you are accused rather, of one of these substantive laws, there are a variety of procedural laws that both govern the substantive laws, make sure that they are firm in their foundation and that they are not overstepping their reach, and they're also making sure, these procedural laws are making sure that the defendant is protected through due process. And that's the supervision of the different rights of those accused of said crimes. So in this chapter, what we're going to do is focus predominantly on three constitutional amendments, four. The fourth, fifth, sixth, and eighth amendments, and we're going to talk about the different procedural laws that come from them and the impacts that those amendments have on due process. Okay, so if we're going to create a law, there are typically 5 things that need to go into a law in order to make sure that that law is good. So 1, are these rules created by the state? Is there a legal sort of boundary that the state puts on different behaviors, if you will? So there's a political aspect of these violations. The state has a purpose for making certain actions illegal and therefore puts a law on the books. Is it prohibiting a specific action? So if I say drug use is illegal, well, what does that mean? Does that mean illicit substances such as cocaine and heroin use? Or does that mean prescription drug use for allergy use? There's a difference between the two, but you have to make sure that in the specificity of your law, you're not going too far outside the bounds of what would be considered illegal behavior. Taking a Claritin would not be outlawed. However, snorting a line of cocaine certainly would. So making sure that you have a strict definition of what actions you are trying to govern makes a key element of a good law. Third, you have to make sure that the law is going to be enforced with a certain amount of regularity. So if somebody kills somebody else, are you going to take into account that person's social status? No. If it's a rich man, if it's a poor man, if it's a black man, if it's a white man, if that person has polka dots, you are still going to make sure that that person is arrested for his or her crime. There is no sort of allowance for social status. The law is going to affect everyone. And in addition to that, you have to make sure there is uniformity in enforcement. So even though the law is applied to everyone, would all of those different individuals be arrested for the same crime? Or because I'm rich, do I think I'm going to get off on this crime and not have to face the punishment? So the courts and the police have to make sure that there is uniformity in enforcement. We're not just going to bust the poor people for drug use. We have to actually go after the rich folks too. We're just not going to go after black people for certain crimes or white people for certain crimes. You go after everybody and make sure that it's enforced across the board. And then finally, is there a penal sanction for this? Because there's no reason in the world for me to have a law if there's not going to be any punishment inflicted on me based on the crime that I have committed. So if I kill someone and there's no recompense for that, I don't go to prison, I don't go to jail, there's no threat of the death penalty, I just walk away from the murder, what good is that law? So you have to make sure there's some sort of punishment attached to the law in order for the law to be considered a good law. So if those 5 things are there, then we have the ideal characteristics in place, and the criminal law is going to be a good one. So when we talk about law just didn't crop up last week. We have a certain origin that came about. So written laws are only about 5,000 years old. Before that time, what we had was just one guy who knew the law and would enforce it, not with regularity and not with uniformity, but would impose the law whenever he or she felt like it was necessary. However, once the laws were written down, now we had something to go to. Now the judges and now the kings and everybody would be able to go to this set of law and look it up. The laws were not changing based on the whims of verbal response. So the most famous set of laws really came about that we have been able to find in the most historically written down laws came about in 2200 BC with the laws of Hammurabi. This is the whole an eye for an eye kind of thing. And the great set of laws with 285 was at that point a pretty explicit list of laws that laid down everything that was illegal at the time. Now we don't have such a vengeful set of laws. There's no more of that eye for an eye mentality, although some people still argue that we should have it, but there is still recompense for the crimes that you have committed. Around the turn of the 12th century, what we had created was this group of traveling judges called the CRIJ. And basically, they ensured that the king's laws were going to be put into place. So the CRIJ would travel around the countryside, and they would make sure that all the peasant farmers and all of the king's constituents would cough up their portion of taxes or their portion of rent for the property that they farmed, and if not, then they could be punished for that. So this is one of the early instances in which the idea of debtor's prison came about. If I could not pay my taxes, or if I could not pay the rent on my farmlands, then they could take me away as punishment for not providing the proper payments to my king. This group of traveling judges and their decision-making skills for who would be punished and who would not be punished really set the foundation for what was later to become common law. Common law was something that came about in a way because we did not necessarily have a specific law written down for that action. So if you think about how cultures and customs evolve over time, there now becomes a need for certain laws to be implemented. But if there was no law that was on the books before then, and now all of a sudden we have an action that has been committed and nobody knows what to do with it, common law is going to be the perfect way for us to be able to punish that individual and still be able to create new law. So common law was used in England and later was taken over to the colonies and put into effect in the newly flourishing United States government. So here in the United States, common law was really derived from case law. So like I said before, if we didn't have a case on the books for a specific action, but we still felt like it was illegal and we took that person to court, dependent on the decision that the court would make, would determine whether or not that law was created. So when a decision was made in a specific case that brought about a new illegal behavior, what happened was it set a precedent. So now when you go to court, most oftentimes lawyers are scrambling trying to find precedent to be able to bring up in the case for evidence to either sway or bias a jury against the defendant. So a fantastic example of this was Roe versus Wade in 1973, the famous abortion case. It was not that all of a sudden women wanted to have abortions. For years and years and years, centuries, women have been having abortions. But what this argument of this case was saying was, is there a legal, more safe way for abortions to happen, and do women have the choice to get an abortion or not? Well, the United States Supreme Court ruled that abortion was legal, and since 1973 it has remained that way. So now the precedent has been turned into law that abortions are not illegal. We have a new law in effect, and you cannot punish somebody for that action. You have to give them the ability to carry out an abortion if he or she, or rather she, not he, sorry, if she so chooses. So you cannot punish that person for something that is not illegal. So this is a reverse form of precedent. So you can see in both ways, depending on the decision of the case, precedent could either form new law outlawing certain behaviors or form new law that's going to allow something that used to be illegal in the past. In addition to creating law via case law, we also allow our legislative bodies in the United States to create law, such as Congress. We gave them the ability to make laws, and now through common law or case law, depending on how the courts interpret different things, the United States Congress, to some extent, state Congresses can also do the same thing. So they can create laws based on whatever the courts are saying. So going back to our Roe v. Wade example, since the United States Supreme Court allowed for that to happen, now Congress can implement a law that allows abortions to take place. So what this is showing is that there are two different forms of lawmaking procedures here in the United States. However, one of our most famous instances in which Congress put together a law was the Bill of Rights, which supersedes the different amendments in the Constitution. And in those Bill of Rights, the Congress at that time put together these different procedural laws that are going to dictate how these laws should be governed, to make sure that defendants are getting their proper dues, that their rights are protected at the time of going to court, and that the country as a whole is not going above and beyond what is required of these laws. They're not too harsh, they're not going too far, they're not having a net widening type of law that's encompassing all illegal behaviors, making sure that they're still specific enough, making sure that there's uniformity in who can be arrested for these different types of crimes. So procedural laws really are governing the other types of laws and making sure that they are being administered in the proper fashion. All right, so here are the different procedural rights that we have that have been found in the Bill of Rights. You probably have heard of most of these: right to counsel, right to a fair and impartial jury. You cannot be tried for the same crime twice, which is double jeopardy. You can plead the fifth and not be compelled to self-incriminate against yourself. These certain things are certainly in the Bill of Rights. We've heard about them before, but what I thought we would do in the next portion of the lecture is really just go through the 4th, 5th, 6th, and 8th Amendments and show you how these different due process rights are really being implemented and how they're being affected in a real world manner. Okay, so the 4th Amendment. This is going to protect us against unlawful search and seizure. So you see on TV all the time police officers showing up to homes and saying, "Can I come in and check things out?" And the homeowner has the right to say, "No, not without a warrant. You can't come in here." So police have to then go back and get that warrant if they want to come into a premises to search it, unless the homeowner is going to allow them to do that. But most people will not, because if there's something incriminating there, go through the proper procedures in order to get this information so you can come search my house. It's in your best interest to make sure that they have the warrant. It's also reasonable under the 4th Amendment, if they think there is enough probable cause that that certain object will be found during that search, then the warrant serves as a legal allowance, if you will, for that search to take place. That we're going through all the procedural steps to make sure that this is done in a lawful manner. Well, what makes you think that perhaps there is probable cause to go in some place to search it? Well, let's say that their police have been investigating a local group of gang members for a while, and they think that I am the gang kingpin, and in our gang we are selling and distributing heroin. So maybe all of the heroin is being stashed in my house. And once they have enough probable cause to think that I might be involved in this heroin distribution scheme, they can get a warrant to come search my house looking for that heroin. However, in the warrant, they have to be very specific. The warrant is not good for anywhere. The warrant is good for that specific address. If they come in my house and there's no heroin, and now they want to come into my place of business, they have to get a separate warrant to go search that second location. So the warrant is good for a specific address, and it's good for searching for a certain object. So in the warrant, they would search my house and they would be looking for the heroin. They could not just come in and look for anything that is incriminating. However, if they come in the house and there's something that's not on the list, let's say they're only coming in looking for the heroin, and they come in the house and on my table I have a 5-pound brick of pot. Now we have a problem that's not on the list. However, it is contraband and the police can seize it. So it has to be found during the search, during the active warrant period while they are in the house. They can come find, if they come in and they find that contraband, they can seize it. There are some issues, though, with the Fourth Amendment and with unlawful search and seizure. If I allow them in the house, as I said before, they don't need a warrant. If they pull me over on the side of the road because I'm speeding and they see in my front seat that I have a bong, oh, it's in plain sight. We have a feeling there might be other things in this car. If the bong is on the front seat and you didn't do anything to hide it, can we search your car? They do not need permission to search my car. They can just search it. In other instances, if there's a fugitive on the run or you're running away from police and you run into a house, the police can come straight into that house and do not need permission because they are in pursuit of a suspect. So there's other things that allow the police to go into dwellings and into businesses without a warrant. There are some exceptions, but for the most part, if the police want to make sure that the materials that they find during the search are admissible in court, the warrant is their best friend for that, to make sure that they have that procedural warrant in place to be able to admit that stuff into court. So, when I was talking before about probable cause, there are different standards of proof that police and courts can use to make sure that they're following along with things. So, probable cause normally comes from after an investigation. We think we have enough evidence against you to be able to conduct this search. However, my other example of I got pulled over on the side of the road and there's something in plain sight, that would fall under probably somewhere between reasonable suspicion and probable cause. It's in plain sight. We think there's something else there. We can now frisk you. We can now search the car. So it's towards the lower end in terms of how credible is their standard of proof. However, as we move up and evidence mounts, you end up getting a better credibility and having more certainty of evidence and a more certain standard of proof against the defendant as you make your way through. However, what has to be noted is that nothing has 100% absolute certainty. There will always be a little bit of doubt. However, if the police and the prosecutors are good at what they do, they should be moving to the right in terms of their standards, and they should be making a good case against the defendant that is hard for the defendant to rebut. So as you make your way through to the right, you have a higher level of certainty, and it makes it more difficult for the defendant to get away from the evidence that is mounting against him or her. Okay, so that brings us to the Fifth Amendment. So the Fourth Amendment is basically about search and seizure, just that one thing. But the next couple amendments that we're going to go through really protects us on a variety of different levels. So the Fifth Amendment, this is when everybody says, I plead the Fifth. That is protection against self-incrimination. But there's other things that are embedded into this amendment that protects us well. So the right to a grand jury indictment. Most oftentimes when you get charges pressed against you by the state, they're going to come from the district attorney. However, it's a little bit different at the federal level. At the federal level, you have the right to a grand jury indictment. At the state level, it's not a guarantee, but certainly at the federal level it is. So at the state level, most oftentimes the charges that are going to be brought against you are going to come from a district attorney. So the grand jury right to it, or the right to a grand jury indictment, is present, but it's not an absolute guarantee compared to some of these other things that are embedded in the amendment. Protection against double jeopardy. This means that I cannot be tried or charged with the same crime twice. So we saw there was a movie probably 10 or so years ago with Ashley Judd called Double Jeopardy, where I think she kills her husband, but he doesn't die the original time, and then she kills him again, and she can't be tried because she was already found and convicted for that crime the first time, even though he didn't really die. So double jeopardy is the exact same crime twice. However, this is not to say if I kill two different people, I can't be charged with murder twice. It just means I can't be charged with murder twice against the same individual. So clearly that movie is a bit of an extreme example, but double jeopardy is a real thing, and you cannot be charged for the same crime twice against the same individual or in the same scenario. And then finally what we have is protection against self-incrimination. So I just said before that you have the right, don't self-incriminate in court. You have the right to plead the fifth. What this is saying is that you do not have to be a witness against yourself. So if you get to the point where you're going to a jury trial, you do not have to testify in court. The Miranda warnings at the time of your arrest, you have the right to remain silent. Anything you say can and will be used against you in a court of law is real. So when they tell you to be quiet, you should be quiet, because anything you say after you say, yes, I understand the rights as they have been read to me, anything you say will be used in court, including confessions. So if you are in a police station and you've been there for a while and you're very tired and you say, I'll just confess, I'll do whatever it is that you want me to do so I can get out of here, that confession is real. So self-incrimination certainly includes confessions. If you are in the police station and you say, I did it, you have confessed to the crime, and that, according to the prosecutor, that shows that you are guilty. So if you are going to be in the situation, it's in your best interest not to say anything. So don't self-incriminate at all. The Sixth Amendment is a little bit different. This is what's happening after you get past the charges and after you get past all of the initial steps. This is really what is happening when you go to trial. So everybody has the right to a speedy and public trial. But speedy is really arbitrary. What does that mean? From the time that I have the charges brought up against me, is that a month? Is that 6 months? It really is going to depend on the type of crime that you commit. So if it's just a lower grade felony trial for drug possession, you probably don't need a whole lot of time to prepare for that trial. However, if you are Timothy McVeigh and you blow up the Oklahoma City courthouse building, the federal building, you probably are going to need a little bit more time to prepare for that trial than if you were that low-grade drug felon. So it really is going to depend on the nature and complexity of the crime, and the judge will be the only one who is going to allow a delay or force either side to hurry up their preparations and get to trial in a reasonable amount of time. Your trial also has to be open to the public within reason. And when I say within reason, probably for good reason. So most trials are open to the public. If you walk into a courthouse Monday through Friday, you have the ability to go in and watch a trial if one is in session. However, if that trial happens to be for Timothy McVeigh, and he is the guy who is on trial for blowing up the Oklahoma City courtroom, or federal building, rather, they're probably going to limit the amount of people who are allowed to come in and watch that trial. Open to the public also means it could be filmed and broadcast on live TV. So a couple years ago, we probably all remember the trial of Casey Anthony. They were having a lottery for seats because so many people wanted to come watch part of that trial. They also broadcasted it every day from the beginning of each trial day until the day ended on public television. So that is a new format in which it is now being open to the public. Probably not the type of format that our founding fathers had in mind, but certainly with the evolution of our culture, we see that now is a different way for the trial to be open to the public. Also, your trial is going to take place in the venue where the crime was committed. So I go back to Timothy McVeigh. He's an excellent example of this. He asked for his trial venue to be moved because he thought he would not be able to get a fair trial in Oklahoma City due to the amount of publicity that was stacked up against him. So they decided that he was probably right, and they moved the trial venue to Denver. So unless there is a specific instance in which you want that trial moved, otherwise it's going to stay in the venue in which you have committed the crime. So with exceptions, you can have it moved, but for the most part, it's going to stay where it is. This also has an impact on your ability to have a fair and impartial jury. So part of the reason why Timothy McVeigh wanted his trial moved was because he did not think there would be a jury pool in Oklahoma City that they could find enough people to sit on the jury who could be fair and impartial. These people were in the place where the bombing happened. The folks in Denver are probably not going to have the same reactions towards him and are probably not going to be as emotional towards the defendant compared to those folks who were in Oklahoma City. So a fair and impartial jury has to have that level of detachment from the defendant. This also means that the jury has to be a mixture of individuals who could be the defendant's peer. So for a long time during Jim Crow in the South, what you would have is you would have a black defendant on the stand and you would have an all-white jury deciding the case against that individual. So it was not a true mixture of people who could be that person's peers. And if you know anything about the Jim Crow era in the South, oftentimes a lot of those folks were very biased against black defendants, and you would have a higher conviction rate for those types of crimes compared to if the defendant had been white. So now things are changing, and we're making sure that there is a mixture of race, of ethnicity, and of gender, and also making sure that people can stay impartial for the type of crime that is being tried in order to make sure there is a proper, fair, and impartial jury on the stand for that particular defendant. It also, in the Sixth Amendment, we have the right to confront your accusers. So when the district attorney brings up charges against you, and if there are witnesses on the stand for the district attorney, you're going to be able to cross-examine those witnesses. Your defense attorney will be able to ask that person questions. You also have the right to be at the trial. It is very, very rare that that defendant chooses not to be there. It hurts the case more than it helps in most instances, but you do have the right to not have to go if you don't want to. But most people choose to be present at the trial. You also have the right to bring witnesses that are going to be favorable to your case. So just like the district attorney can bring witnesses forward to create a case that is going to be biased against the defendant also has the right to subpoena individuals, and basically that's just a written court document that says you have to come to court and testify on behalf of this individual, or you face jail time yourself in pursuit of making sure that the due process rights of this defendant are being met and being satisfied. So you have the right to call up witnesses to help your case, just as the district attorney has the ability to bring up witnesses that will hurt your case. Both sides have the right to cross-examine those witnesses. You do not have to testify, however, as part of the Fifth Amendment during cross-examination. So that's one of the things where you don't have to get up there and testify at all, and the district attorney cannot cross-examine you if you do not take the stand. Furthermore, in the Sixth Amendment, you have the right to counsel. So this basically means that you have a right to an attorney, is part of the Miranda rights, as we learned before. But part of this is the right to effective counsel. You can be your own counsel if you want to. People try it all the time and it does not work out very well. But basically, right to counsel is a private hired attorney that you pay for out of your own money. If you cannot afford attorney and a private attorney, the state will provide you with a public defender. For the most part, public defenders are not going to do as well of a job as a private attorney just due to the basic amount of caseload that they have. Your private attorney might only have you as a client right now that they're focusing on, but a public defender is oftentimes stretched pretty thin and might have 30, 40 cases on an active caseload that they have to take care of. So their resources are stretched thin and their time is not always yours alone. So even though your public defender is stretched thin, is he or she ineffective? And if the answer is yes, then your case potentially could get thrown out. That's the same question that you will ask about your own private attorney. But right to counsel really means the right to an effective counsel. Has your attorney done anything that is going to hurt your chances of being acquitted? Has your attorney done anything that is helping the district attorney's case? Or is your attorney being more hurt than help in terms of your case? And if that answer is yes, if your counsel is ineffective, you can appeal on grounds of ineffective counsel and you can get your case thrown out in some instances if you can prove that that is true. So right to counsel doesn't mean just that I have an attorney, but that I have an effective one. Finally, the last amendment that we're going to go through today is the Eighth Amendment, and this covers two different things. First, it covers the right to protection against excessive bail and fines. However, it does not guarantee that you will be released on bail. That is still up to the discretion of the judge whether or not you are going to be released. However, when you go up for your initial bond hearing, your bail is going to be determined by a variety of different aspects regarding your case. So, what kind of crime did you commit? Was it very serious? What is the character of the defendant? Have you committed crimes before? Is there a lot of evidence against you? Do we think that you're going to flee? Do we think you're going to try and escape the country and not show up to court? So there's a variety of different things that go into whether or not bail is even going to be granted. Those same aspects are going to go into how much bail is going to be presented to you. So if you have killed somebody, your bond amount is going to be a lot higher than if you are just a low-grade felony drug defendant. You would probably not expect similar bond amounts to be given out to every person. If this is not your first crime, if you are a repeat offender, your bond release is probably going to be in a higher amount compared to a first-time offender, simply because you've been in the system longer. And finally, can you even pay? If you are a poor, indigent person, they're probably not going to release you on $1 million bond. However, if you are a poor, indigent person who killed someone and cannot be trusted to be released back into the community, they just might release you on a $1 million bond to ensure that you're going to stay in prison, or they might just deny you bond altogether to make sure that you're going to stay there. So the first portion of the Eighth Amendment is the bond aspect of it for the excessive bail and fines. And the second part of it is the right against cruel and unusual punishment. So this is not saying that we cannot take extreme measures to punish you. However, this is saying that that punishment cannot be cruel and unusual or excessive for the crime that has been committed. So back when the country was first established, death and more, if you want to say violent types of punishments, would take place in exchange of incarceration. Now the most likely punishment that you're going to get is either a fine, incarceration, or probation. However, back in the 1700s, if you were caught stealing, there was a good chance you might lose a hand. So when the country was established, they said no cruel and unusual punishment. And what that meant at the time of the creation was no punishment that had extreme torture, unnecessary unnecessary cruelty, or lingering death. Not that we can't punish you by the death penalty, just that it has to be a quick death and not a lingering one. So it was just making sure that things were as fair as possible for the time period we were in. For 120 years after the establishment of the Eighth Amendment, we were still running by those rules. However, that is going to change in 1910, and they're going to say nothing excessive for the crime that you have committed. So if my victim did not die, is the death penalty the right punishment for me? If all I did was rob somebody, is the death penalty a good punishment for me? So nothing too excessive based on the crime that you have been convicted of. And of course, with this ruling, they also said that things are going to change, things are going to evolve, and the same punishments that were fine in 1910 are probably not going to be okay in 2014. So for a long time, what you saw with the death penalty, that the death penalty was extended to everyone, including children. So if I committed a very violent crime against somebody, but I did not kill that person, for a long time I could still receive the death penalty. If I was a minor who killed somebody, I could receive the death penalty. It was not until 2005 in which juvenile offenders were no longer eligible for the death penalty. The mentally ill for a very long time was allowed to be put to death. Now that's not allowed. That is considered excessive and it's considered immoral. So you see how this particular punishment has evolved over the years, specifically from this 1910 time period when that decision was made to have this evolving standard of decency. However, even though we try really hard to make sure that these individuals are protected, we're not efficient at it 100% of the time. There are still what they call these miscarriages of justice. Particularly, I just want to touch briefly on this idea of wrongful convictions. And they happen an estimated 0.1% of the time. And you might say, well, that's a very small amount. If we're getting 99.5% of them correct, why are we really concerned about this 0.5%? Well, if we break it down into numbers, your book touches on the statistic that in 2010, 6.5 million people were convicted. Out of that 6.5 million convictions, 32,000 of them would be wrongful convictions. So that's just not an insignificant number. That's a lot of folks who are now incarcerated who have been convicted for crimes that they did not commit. And we're not talking about they didn't have a good enough case to debunk the DA. This is something happening to make sure that they get convicted. The eyewitness identification was biased due to something that the police officers did. The police investigations themselves were tampered with, or evidence was wrong, or it should not have been admitted into court. There were prosecutorial errors that were taking place. There was an unlawful confession. As I said before, when we were talking about Miranda rights and the right to remain silent and don't self-incriminate. If I'm sitting in a police station for 24 plus hours, I'll say anything to get out of there. Well, that confession, even though you might be innocent and not guilty and you didn't really mean it, that confession is going to go through, and that's proof that you're guilty. So when things like this happen, they result in these convictions, and the innocents involved in it, the innocent suspects who didn't really do it, are going to prison for a long time, even though they have been wrongfully convicted. So it is a big deal when these things happen. Even though it's just 0.5%, that's still 32,000 folks who are in prison for something that they did not really do and are innocent of that actual crime. So the law chapter really speaks mostly about these procedural issues and making sure that the defendants for these crimes are being treated properly and that their rights are not being violated. So from a legal aspect, we see that those actions happening. Really, this is going to end Unit 1. The next thing you have coming to me is Quiz 1. You have a paper that is about to be turned in if you have not done so already. So make sure that you're ready for the quiz and that your paper is submitted. And Unit 2 is going to begin with Chapter 5 as soon as your quiz is finished. So that lecture will pick up there. However, in the next unit, make sure that you are aware that it is only a 2-chapter unit. This one was 4, the next one is 2, so your quiz for Unit 2 is going to be sneaking around a lot quicker than this one was for Unit 1. So again, as I constantly remind you guys, get in touch with me if any of this was unclear or if you have questions. And if not, good luck on your next quiz, and I will see you all in Unit 2. Have a good one and good luck.